Hello, I am Sohan Sidhu, a partner and immigration solicitor at Gross & Co. I have been practicing immigration law for 17 years, and in this webinar I will be talking about the Home Office Civil Penalty Scheme and summarising the duties imposed upon employers. I will then talk about the penalties which can be imposed by the Home Office and the fines, which start at £15,000 per illegal migrant worker for those with a first offence. For repeated offences, the maximum starting penalty is £20,000 per worker. If an employer knowingly employs an illegal worker, then this is a criminal offence and can lead to a term of imprisonment. I will be providing information on how we can provide safeguards and hopefully prevent or at least minimise the risk of civil penalties being imposed upon employers by UK visas and immigration, which I will refer to as the Home Office throughout this webinar. As an employer, you have a responsibility to prevent illegal working in the UK by ensuring that your employees have the right to work here. The illegal working provisions of the Immigration, Asylum and Nationality Act 2006 came into force in February 2008. Where the employer has been found to employ a person aged 16 or over who is subject to immigration control, a civil penalty is payable unless that person has been given valid and subsisting leave being a legal word for permission to be in the UK, and that permission does not restrict them from taking the job in question, or the person is in a category for which employment is also allowed. Whilst you have a duty to prevent illegal working in the UK by carrying out document checks on employees, failing to conduct these checks is not actually a criminal offence in itself. However, if an employer only carries out checks on people who they believe are not British citizens, then the employer could find themselves being accused of discrimination. Anyone who believes that they have been discriminated against, either directly or indirectly, by an employer or indeed a prospective employer because of their race, may bring a complaint before an employment tribunal, subject to the appropriate tribunal fees being paid. If the complaint is upheld, then the tribunal would normally order the payment of compensation. It is worth bearing in mind that there is no upper limit on the compensation which the tribunal may order. It is therefore important that you have a statutory excuse, namely a defence, for all prospective employees. This would protect you from liability, from the imposition of a civil penalty, whilst at the same time demonstrating a transparent and non-discriminatory recruitment practice. In the next section, we will look at the right to work checks, which the employer is required to undertake. Conducting right to work checks, the stages will be as follows. You are required to obtain the worker's original documents from either List A or List B, which I will deal with later on. The documents need to be checked. You must make and keep copies of the documents and also record the date when the check was done. Looking at Step 2 in more detail, you must check the documents in the holder's presence, photographs and dates of birth are consistent with the holder's appearance, the visa or permit providing right to work is not expired, that the document is valid as per List A and B, which we will deal with later on, that the worker is able to do the work in question, for example, whether there are any restrictions on their employment, and finally, whether the documents look genuine. Looking at Step 3 in more detail, you are required to photocopy the documents in a format which cannot later be altered, retain copies securely for the period of employment plus 2 years following the end of employment, keep a record of documents of which copies were taken and by whom. For passports, you must photocopy the photo page along with any page with details such as nationality, date of birth, signature, issue and expiry dates, biometric information, and UK visa or residence permit pages. For all other documents, a complete copy of the documents must be made. If the documents produced come within List B of documents, then you must diarise repeat checks and conduct the 3-step check again. In addition to the List B documentation checks, you are required to obtain and retain a copy of evidence from the student's education sponsor. The evidence must show the student's term date, vacation date, and cover the duration of their period of study in the UK for which they will be employed. It is important to bear in mind that Tier 4 students do have restrictions on their right to work. Many companies we see have failed at some stage to follow these simple guidelines. If a prospective employee cannot produce their original documents, then it is important to ascertain why this is the case. It may well be that the worker has submitted an application to extend their visa or permit in the UK. If that is the case, then you are required to check with the Home Office Employer Checking Service as to whether the worker still has a continuing right to work. I will talk about this in a little more detail later on. The acceptable documents are contained within two lists, namely List A and List B. List A contains a list of documents which may be accepted for checking purposes for a worker who has the permanent right to work. If an employer follows the right to work checks, then they will establish a continuous statutory excuse for the duration of the worker's employment with them. List B contains a range of documents which may be accepted for checking purposes for a worker who has a temporary right to work. If an employer follows the right to work checks, then they will establish a time-limited statutory excuse, but they will be required to carry out follow-up checks. The acceptable documents contained in List A include a British passport. In terms of List B, this list is divided into two, namely Group 1 and Group 2. Group 1 documents include a current passport, endorsed to show the holder is allowed to stay in the UK and is currently allowed to do the type of work in question, such as a current biometric residence permit. These documents are documents where a time-limited statutory excuse lasts until the expiry dates of the leave to remain, endorsed in the passport or in the biometric residence permit. Group 2 of List B includes documents where a time-limited statutory excuse only lasts for 6 months. There are 3 documents contained in this list, and they include a certificate of application issued by the Home Office to a family member of a national of a European Economic Area country or Switzerland, stating that the holder is permitted to work, which is less than 6 months old, along with a positive verification notice from the Home Office Employer Checking Service. If you conduct the prescribed right to work checks, then you will establish a statutory excuse as follows. In List A, your statutory excuse will be for the whole duration of your employee's employment. In this case, you are not required to repeat the right to work check. For employees who come within List B, your statutory excuse will be limited because the employee will have restrictions on their permission to be in the UK and to do the work in question. To retain the excuse, you will need to undertake follow-up right to work checks. It is important to establish whether the employee made an in-time application to the Home Office. This means whether they submitted an application to the Home Office on or before their current visa or permit expired. If they did not, then they would not have continued permission to work in the UK. There is no flexibility here whatsoever. Maximum starting penalties are £15,000 per worker for a first breach and £20,000 per worker for a repeat breach, which is defined as being a civil penalty notice or a warning received in the last 3 years. The mitigating factors which can reduce a civil penalty are that, firstly, you reported the employee to the Home Office before the Home Office conducted an immigration visit. Do have a bear in mind potential data protection issues here, however. Secondly, you cooperated with the Home Office during an immigration visit. And finally, you have effective document checking practices in place and are generally compliant with your obligations to prevent illegal working. It is worth bearing in mind that the third mitigating factor can only be used if the other two apply. Also, if all mitigating factors apply and it is a first breach, then you are given a warning rather than being issued with a civil penalty. The first 2 mitigating factors will result in £5,000 reductions each to a civil penalty. You will have a statutory excuse if you have carried out the appropriate right to work checks using acceptable documents before the employment commenced. Some examples which will not provide a statutory excuse include 1. You cannot provide evidence of having conducted appropriate checks. 2. You have accepted a document which clearly does not belong to the holder of the document. 3. You have conducted a check and it is reasonably apparent that the document is a false document. If you receive a civil penalty notice, you will have 28 days from the date given in the notice to object to it. You can object on the following grounds, namely that 1. You are not liable to pay the penalty, and this could, for example, be because you are not the employer of the illegal worker, or 2. You have a statutory excuse, and this could be because you have carried out a document check, or 3. The level of the penalty is too high. When the Home Office has decided upon the objection notice, or they have not informed you of a decision within 28 days, then you may bring an appeal to the county court. The grounds upon which an appeal can be based are essentially the same as the grounds for objection to a civil penalty. You can be named and shamed on the Home Office website, and this could have an extremely damaging effect on your reputation. The current information contained on the Home Office website shows that in the last quarter of 2013, in the Midlands region, the fines levied by the Home Office range from between £2,500 to £30,000. If you hold a sponsorship licence under Tier 2 of the points-based system, or you're looking to apply for a sponsorship licence, then a civil penalty can have a negative impact upon a current licence application, or indeed a future application. A civil penalty can therefore negatively affect an employer's ability to sponsor migrant workers. If you are subject to immigration control, for example, you hold a Tier 2 visa, then any civil penalty will be recorded by the Home Office, and this will be taken into account when considering any future application which you may make to stay in the UK. There are various steps which we can take to help you, including conducting an immigration audit of all employees. We can check the work entitlement of all employees, and if any problems are encountered, we can advise upon appropriate action which needs to be taken. We can also conduct a pre-hire audit, and can therefore advise upon the work entitlement of a prospective employee before a job offer is made to them. If you are issued with a civil penalty, we can advise upon the merits of objecting to the civil penalty or appealing to the county court. We can also advise whether a statutory excuse applies. If it is deemed that a civil penalty is payable, then we can negotiate with the Home Office to put forward a payment plan. I hope you found this webinar helpful, and if you do have any further questions or issues which you would like to discuss with me, please don't hesitate to get in touch. Thank you.